morning, everyone. This is the stakeholder meeting to discuss the Joint Financial Regulatory Agency's pre-comment draft of home equity interpretation amendments implementing SJR 60. My name is Matt Nance. I'm the Office of Consumer Credit Commissioner's Deputy General Counsel. I'm joined by other members of our home equity work group, Consumer Credit Commissioner Leslie Pettyjohn, Credit Union Commissioner Harold Feeney, the Department of Banking Senior Counsel Everett Jobe, and the Department of Savings and Mortgage Lending's Associate General Counsel Roberto Ramirez, as well as Kimberly Bio, a legal assistant with the OCCC who's going to be helping to run the webinar. I really want to thank everyone for coming to our meeting as well as listening online. Getting input from stakeholders is a really important part of the process of developing these interpretations, and we believe meetings like this help us produce the best interpretations possible. We are holding this meeting on GoToWebinar. Some of you might be listening on your phones, some may be watching on your computers, some may be doing both. For those of you watching on your computer, there's a window where you can submit questions. If you have technical questions about using the webinar, you can type them and Kimberly will try to answer those. If you have any questions or comments on the interpretations themselves, go ahead and type those at any time. I'll be getting to those as well. And if you're on a computer with a mic, there's a function allowing you to raise your hand, and then we can let you make a comment verbally. So the meeting is in two basic parts. In the first part, I'll briefly summarize the anticipated timeline, the proposed constitutional amendments in SJR 60, the interpretation amendments in our pre-comment draft, the draft Spanish disclosures, and the questions we sent out to stakeholders as part of the meeting notice. And then in the second part, we'll turn it over to you to provide your questions and comments on the draft. For those of you here in person, we do have a table with a mic where you can come up and share your comments if you'd like. If you have shorter comments or questions, you can share them from your seat, town hall style, but keep in mind that if you do that, I'm going to need to repeat the comment for those listening online so that they can hear it. And if you'd like to follow along in our pre-comment draft and meeting notice, there are copies in the back of the room, and the digital copy is on the OCCC's recent and upcoming rules webpage. So first, I'd like to say a little bit about the process and timeline for these amendments. We are accepting informal written pre-comments until 5 p.m. this Thursday, September 28th. We call these pre-comments because we accept them before the official comment period that comes later. You can email those to Lori Hobbs. We plan to propose the interpretation amendments at the Finance Commission's October 20th meeting and the Credit Union Commission's November 3rd meeting. The commissions will vote on whether to publish them for comment. If SJR 60 is approved by voters in the election, then the interpretations will be published in the Texas Register in late November. There will be time when you can file official comments during that period, late November and December. And then if things go according to schedule, the interpretations would be up for adoption at the Finance Commission's February meeting and the Credit Union Commission's March meeting, and would be effective in late March. Updates are available on the OCCC's recent and upcoming rules webpage, and we'll also be posting audio of this meeting. So next, I wanted to briefly summarize SJR 60. This is a resolution passed by the Texas Legislature earlier this year. It'll be on the ballot in the constitutional amendment election on November 7th, 2017. If approved by voters, it will amend the Texas Constitution's home equity lending provisions. And SJR 60, getting a thing from my computer to make go away. Okay. And SJR 60 relates to 6 issues. First, it replaces the current 3% fee cap with a 2% fee cap and says that 4 types of fees are excluded from that cap: appraisal fees, property survey fees, mortgagee title insurance premiums, and title report fees. Second, it removes the current prohibition on a home equity loan for agricultural property. Third, it adds some depository institutions to the provision on authorized lenders and has an update to the phrase mortgage broker. Fourth, it allows a home equity loan to be refinanced as a non-home equity loan if 4 conditions are met: a 1-year timing limitation, a limitation on advance of funds, an 80% loan to value limitation, and a required disclosure. Fifth, it amends the 12-day consumer disclosure to make conforming changes. And sixth, it removes the 50% limitation on additional debits or advances for home equity lines of credit. So next, I wanted to briefly describe our interpretation amendments in the pre-comment draft. First, in 153.1, 5, and 14, we're replacing references to the 3% cap with 2%, and we identify the types of fees that may be excluded. Second, in 153.17, we make changes to identify the lenders authorized to make home equity loans. Third, in new 153.45, we identify the conditions to refinance a home equity loan into a non-home equity loan. And fourth, in 153.84, 86, and 87, we're removing references to the 50% limitation for HELOCs. In addition to the interpretation amendments, we have draft Spanish disclosures that we're interested in getting stakeholder input on. We have two translations. The first is an updated translation of the 12-day consumer disclosure, and the second is a new translation of the new refinance disclosure under SJR 60. Those translations aren't really part of the interpretations, but if SJR 60 passes, we would plan on posting those to the Finance Commission's website so that lenders could use those in transactions conducted in Spanish. So that's a brief summary of the draft amendments and disclosures. We're interested in hearing any input stakeholders have on the drafts. In particular, we identified 8 questions where we'd like to see what stakeholders have to say. These questions are listed in the meeting notice, but I'll sum them up quickly. The first question is whether in 153.5.7, should the phrase mortgage broker be amended? Questions 2 through 5 are about whether stakeholders believe that specific parts of the amendments in the pre-comment draft correctly reflect SJR 60. That's kind of questions 2 through 5. 2 is about 153.5.13, which says that the excludable appraisal fee is limited to the fee paid to the appraiser, not to an appraisal management services company. Question 3 is about 153.5.15, which says that excludable title insurance premiums are limited to the Texas Department of Insurance basic premium rate for title insurance, plus premiums for applicable endorsements, and TDI's rules govern authorized amounts and the applicability of endorsements. Question 4 is about 153.5.16, which says the title report fee may not be excluded from the 2% fee cap if the loan is already covered by title insurance. And 5 is about new 153.2a regarding the term actual costs in the condition on refinancing a home equity loan to a non-home equity loan. Our draft says that actual costs must be identifiable, must be actually incurred, and must comply with applicable law. That's questions 2 through 5 about specific provisions in the draft. Question 6 is about whether stakeholders think a title is appropriate for the new refinance disclosure and whether there should be a Spanish translation for that title. 7th is an interpretation needed on the content of the new affidavit described in new section 50F-1 of SJR 60. And 8th, do stakeholders believe that some sort of informal interim guidance is appropriate before the interpretations become effective, which we anticipate is going to be March 2018 at the earliest. So that kind of concludes my summary of the amendments and our questions for stakeholders. I'd like to open it up for your responses to those questions or any other issues you'd like to comment on in the drafts. Again, those listening online can type in any questions through chat. If you're here in person and you have a very short comment, you can say that from your seat, and I'll repeat it for the webinar, but if it's longer, please come up to the mic and share it. Yeah.
Matt, John Fleming, Texas Mortgage Bankers Association. I want to comment on, do you want me to come to the mic?
Sure.
That'd be great.
Once again, John Fleming, Texas Mortgage Bankers Association. I want to comment on the first posed question with respect to whether current 153.57 should be amended to change mortgage broker to mortgage company. I think I would raise a predicate question, which is whether that phrase even needs to be included at this point. This deals with third-party charges, and I think originally the intent was that it distinguished between broker charges for persons who originate that do not make the loan and those persons who are listed as an original creditor. In many cases, a mortgage broker, now a mortgage company, may in fact be listed as an original creditor. So as you look at this, I think you might keep in mind that the definition of third party means a charge paid to somebody who is not the original creditor, and determine whether or not that term needs to be retained or not. If you go to mortgage company, then you create an ambiguity, I think, when you have a mortgage company who actually is the original creditor, even though they may be table funding and sending it on elsewhere.
Thank you. Okay. Any other comments, responses to questions? Okay, I've been told it's good to wait a few seconds just to make sure. So I'll just wait to see if anyone thinks. Do we have any on the chat? Nothing on the chat? Okay. Just wait a few seconds.
I'll ask a question.
Sure. Come on up.
Real quickly. This is Thomas Vetters with Robertson Antiques Vetters. The question that related to whether there should be a title, I think there should be a title, and I would say that in studying this, I think there was even some immediate confusion potentially of, wait a minute, did we amend the original 12-day? Oh no, this is a different 12-day. Oh, wait a minute, this isn't a 12-day at all as it relates to home equity. So I think it might be helpful for there to be a title that preferably doesn't use the name 12-day, even though we know the current 12-day doesn't have that in the title either. But I think industry knows the 12-day disclosure as the home equity. So I think you raise a good question of whether there should be a title. I think there should. Unfortunately, I don't have a magic recommendation for you to what it might be, but I think that's a good idea. And then as it relates to the affidavit on the rate term refinance, I don't think I wouldn't necessarily want you to promulgate the affidavit, but I think it could potentially be helpful that you might consider a title for that somehow corresponds to the previous point, because I think there could easily be some confusion around those that some simple titles could lead to.
Thank you.
Yes, thank you. Okay. Any other comments? None. Okay.
I'll comment again.
Sure.
Good,
Come on up. Yeah.
Thomas Vetters again, Robertson Antiques Vetters. I don't know if it's appropriate for you guys to even comment, and I think you've deferred rightly to the Texas Department of Insurance Commissioner. But as I look at which of those mortgagee title endorsements are in or out of the 2%, again, looking at this, I realize that we can amend mortgagee title policies without an endorsement, for example, the tax area. So if we're doing a not yet due and payable, or we're adding a tax amendment, that may not necessarily be an endorsement. So it might very well be for the Texas Department of Insurance Commissioner to clarify that, in my view, I think it's the intent for those to be excluded, because that's what we're doing. But I did notice that nuance in there that I just thought I would bring up. And then we've got a lot of non-home equity specific endorsements that are routinely issued with mortgagee title policies. And so my view of this is those would be excluded. But I'm thinking that you guys are saying, well, that's something for the insurance commissioner to do, which that may very well be perfect. But it sure would be good to have clarity on those as we start going into drawing this paper in the event SGR passes.
Okay, and just so I can clarify, so you're saying that in connection with these title insurance policies, there are amendments that are not endorsements specifically identified by TDI, and you were looking for clarity about those amendments and whether.
Well, I could amend. I think industry would call these tax amendments. So, for example, if we're saying we want to ensure all the taxes have been paid, we can do a tax amendment where we're going to amend. In my view, that is an endorsement to the policy, but it can also be done where it was simply amending the language that was there. So if we brought back and said any of these changes that are directly related, which is I hope where I think we're going, that is an endorsement to the policy and we're good. But out of an abundance of caution, I just think that if there is a way to clarify that, whether it's with you guys or with the insurance commissioner, there are, obviously that's regulated, there's appropriate endorsements on a mortgagee policy that are there. There are a myriad of other endorsements that are simply not available. So I don't think there's going to be an opportunity for abuse. I'm just seeking the clarity to where somebody might come back later and say, oh, well, that's not the T42, that's the home equity. So, that could be a question. I don't anticipate that, but, given that sometimes we have to look at these glass half full and what's going on, I just raised that, and if there's a way to easily clarify, I think that would be helpful.
Thank you. We do have a comment from someone.
Okay, Kimberly, would you read that?
Yes, we have a comment from Ms. Erickson with Wolters Kluwer. She says, they provide documentation for home equity loans in Texas. We have begun creating documents. For the new notice, question 6, we did come up with our own title. Notice concerning refinance of existing home equity loan is the title we are using on our document, which is still in draft stage. Does this seem sufficiently clear? Is it appropriate to use this until there is an official title?
Kimberly, can you read again the name of the title that's being used?
I sure can. It's Notice Concerning Refinance of Existing Home Equity Loan.
Okay, so that's something we could take a look at. I think our interpretations, described it just for purposes of titles as refinance disclosure. We can talk about as a work group kind of what an appropriate title might be, and kind of whether that phrase, notice concerning refinance of existing home equity loan, would be appropriate. But I appreciate that suggestion.
Martin Green from Polinsky Vital Green. Just one comment on the proposed title that we just heard. The one concern we would have is just that if you can refinance a home equity to another home equity loan, so it probably needs to refer to refinance of a home equity loan to a non-home equity loan.
Okay, thank you. Any other comments?
Are we still on your questions, or have we moved on?
You're free to comment on our questions or any other comments you'd like to raise. Yeah.
John Fleming, Texas Mortgage Bankers. My comment goes to $153.514 on the exclusion for property survey fee, found on my page 3 of the pre-comment draft. And it goes to the last phrase, which says, and must comply with applicable law. I'm not sure why that was included. I don't think it is included in the constitutional language, I think it would be appropriate to say it has to be a person licensed under the Texas Occupation Code. But I think you introduce uncertainty if you suggest that the survey itself must comply with applicable law, because that, at least in theory, opens up an impermissible charge if, in fact, there is a technical defect in the survey that doesn't comply with that technical requirement of the statute. So because that is not included in the Constitution itself and adds uncertainty, we don't think it needs to be in this, because it creates a risk that that charge would be accidentally excluded if on subsequent evaluation somebody said, oops, survey was not done in accordance with the statute.
Okay, thank you.
Thanks.
And it's been pointed out to me that that phrase occurs elsewhere, like that the endorsement must comply with the applicable law. That's a TDI requirement. And again, that should be between the TDI and the insurance company, or the insurance company. That's not something the lender controls. And again, adds another potential source of uncertainty.
Do you have any comments on kind of existing places and the interpretations that aren't being amended, where we use phrases like to the extent authorized by applicable law and 7, or those kinds of things? Is there a difference because the lender does or doesn't control those?
To the extent authorized by existing law, depends on where that phrase is. I know that in some cases that has to do with the charge that may be made. But in connection where you are requiring the lender to go back and basically do a homework check of some third-party provider, that seems to me to open up some uncertainty. TDI has promulgated forms that are supposed to be used for their endorsement and amendment process. Presumably anything that a title company would do would meet that requirement, but at least in theory, you might find a local title agent who uses a non-conforming form. That would not necessarily be noticeable to the lender until after the closing, that actual title policy was issued. So I think in those places where, like the survey and the title commitment or title policy, those places where the lender doesn't have any real control over the form, to make them check that out would be appropriate. I think you'd have to do a line-by-line search. I did not do that. I simply looked at the proposed amendments.
So, John, I understand your point. However, it seems to me in the past there's been some discussion about the usefulness of these interpretations, and that perhaps we should sort of point the way in a sense when there are other requirements and applicable law that might impact some of these provisions. And I know that's been at least in the past, there's been some areas where we do sort of put that notice in there that someone doesn't believe that somehow that there are no other requirements that may apply. I would think most people in the industry would assume that, but that there are other requirements that apply. I just wonder if you had any comments on that issue.
I think that's why you have to look at it on a provision-by-provision basis. I think that there are some areas where to say as authorized by law or may be authorized by law would be appropriate. But I think there are other cases where it would not be appropriate. Unfortunately, it's one of those areas that doesn't have a one-size-fits-all response.
Okay.
I do think that there are some cases where it would be appropriate to say is provided by applicable law.
Okay. Okay, thank you.
Okay. Other comments on our questions or any other issues you noticed?
Marty Green from Polonsky Vital Green. On the appraisal fee, I have been informed by a number of my clients that certain of their AMC companies do not break down their fee where they have a separate disclosure of the AMC portion, and have asked questions about how that would be taken into account in terms of the interpretation.
Just so I can be clear, the clients are saying that the appraisal management companies don't break down the fee between the fee paid to the individual appraiser for the appraisal services and the fee for appraisal management services of the company?
That's correct.
Okay. I'm interested in hearing more about that. It was my understanding that the Texas Occupations Code required a breakdown of that fee. So if you have more information, we're definitely interested to hear that.
They've asked the question. These are national lenders, and so they may be getting it from a national provider, and it may be in Texas that they're getting it, but not outside of it.
Okay. Thank you.
I have another comment.
Okay.
I have another comment from Ms. Erickson. It says, with regard to the Spanish translation for the existing 12-day notice, in order to deliver content to our customers, lenders or vendor partners, so that they may make Texas home equity loans without interruption, we are moving ahead with our documents now. We are going to use the proposed Spanish translation now and then amend the documents immediately if the final Spanish translation differs from the proposed. What this means is that lenders may be using the proposed Spanish text for a short period of time before the documents can be updated and implemented for the lenders to use. Do the regulatory agencies have any concerns about this approach? With regard to the Spanish translation for the existing 12-day notice, in order to deliver content to our, I'm sorry, it looks like it's repeating itself. So I think we just end there. Do the regulatory agencies have any concern about this approach?
Okay, so what we have put out there is just kind of a proposed draft. I would encourage anyone, or Ms. Erickson, if you're listening, to give us an idea of, like, when would we need to post the final Spanish disclosure in order for lenders to be able to turn around and use it starting January 1st. So if we could get more information on that. Like I said, we kind of envisioned these disclosures as proposed disclosures that we would get stakeholder input on and then be able to finalize. So if there's some date, whether it's December 1st or something like that, that we could get the final versions of the Spanish disclosures up so that lenders could be using those final versions, I would be interested to know about that. I guess I'll wait for Ms. Erickson to type a response if she would like.
Not like my iPhone, I can't see the little dot.
Yeah. Right.
Okay, she says that they try to deliver 90 days in advance so that lenders and vendor partners can implement tests and train staff on the changes. I know you can't provide 90-day notice, but 30 to 45 in advance of the effective date would be good.
Okay, that's good to know. We will try to take that and consider that. And kind of a related issue, it's the reason for our question 8 was about interim guidance. I understand there's a desire to, get some sort of guidance before late March when we anticipate the interpretations will go into effect. If there's a desire for that, we're interested in hearing about that. But again, it would necessarily have to be informal in nature because just given the schedule of Finance Commission and Credit Union Commission meetings, the kind of officially adopted interpretations would take at least until March to issue.
I'll say, Thomas Fetters likes that idea.
Okay. The idea of informal guidance.
Hey, we could call it
Okay.
regulatory commentary on home equity lending procedures 2.0. I'll offer
We
it.
got That takes me way back. Long time ago.
Any other comments? Any issues in the rules? Excuse me, the interpretation. Yes, John.
John Fleming, Texas Mortgage Bankers. My comment goes on page 7 of the draft. It has to do with subparagraph C relating to the delivery of the refinance disclosure.
Mm-hmm.
There are 2 applicable time periods with respect to that disclosure. The first timing issue is it needs to be sent within 3 days of application. The second one is that it needs to be sent at least 12 days prior to closing. If the disclosure is sent by mail and there is a 3-day presumption of delivery, then if the notice is sent 1 day after the application is made, then it may not be timely. I think in writing that, there needs to be a distinction made between compliance with sending the notice within 3 days and the 12-day ahead of closing. I think those 2 could be distinguished so that it would be timely. It is deposited within the 3 days, even though it may not be received until after, but for computing the 12-day closing period, you retain the mailbox rule.
Okay, so you're saying it needs to be put in the mailbox within 3 days after the application, even if it might get to the property owner 6 days after the application.
Yes.
But then when you're computing the 12-day period,
For closing.
right, you add 3 days to the date you put it in the mailbox, and then 12 days to that.
Right.
Is there some kind of basis in SJR 60 for us to kind of make that distinction?
Yes, when
Okay.
is notice given,
Okay.
okay?
Oh.
You can define when the notice is given.
Okay.
Versus when it was received. And I think I don't know if these were the pre-Norwood interpretations or post-Norwood, but I think there is that concept somewhere else in the existing interpretations. I can't remember.
Yes. We had an interpretation for the 12-day consumer disclosure,
Right.
saying that for purposes of that 12 days,
Yeah.
you should allow a reasonable period
Yes.
for delivery, and 3 days constitute rebuttable presumption.
Right.
And that interpretation was upheld by the Texas Supreme
Right.
Court in the Norwood
Right.
case.
But I think in this case, because unlike the existing 12-day notice, there's a requirement that it be given within a certain time frame, that you need to account that it needs to be deposited. Otherwise, you may have a requirement that no one can ever meet, and I don't think that was the intent.
Okay, what D says is the lender provides the owner the following written notice.
Right.
Not later than the 3rd business day after they submit,
Right.
and at least 12 days before.
Right.
So kind of, it
Yes.
says provide, in other words, kind of makes available to.
Right.
Okay, well, we can think about that. My concern is that, that issue was kind of litigated as part of the Norwood case, and, my kind of understanding was that providing meant the owner has actually received it, but, I'm interested in hearing.
If you have specific
no.
language suggestions, we'd be interested in looking at that.
Yeah.
Right. I just think that it needs to be practical, and
Yeah.
I don't think that it would be a practical construction to say you have to give it on the very day the application is received. That just isn't going to work in the real world.
Okay.
Thank you.
Okay, any other comments?
Thomas Fetters, Robertson and Chief Fetters. I have a comment on number 2 in the form of a question. We know SJR 60 uses the term appraisal, and you guys have rightly used the term appraisal. We know the Constitution uses the term appraisal or evaluation. Is there any thought or intent of whether a fee or charge for an evaluation would be covered by the appraisal?
Okay, I'm sorry, I'm just trying to.
I just happen to be able to read that section if you want from 50H.
Okay. Okay, you're reading from 50H?
50H of the Constitution, not in your.
Oh, okay, right. Okay, go ahead.
Just the subsection 1, the value acknowledged to is the value estimate in an appraisal or evaluation prepared in accordance with a state or federal requirement applicable to an extension of credit under subsection H6.
Okay.
So to re-ask the question, is an evaluation intended to be excluded, or would it only be the appraisal? Because we're clearly talking about 2 different animals here.
Mm-hmm.
And I don't know that have an opinion either way other than certainty.
Okay. Yeah, what we were taking a look at was new 50A6E, little Roman numeral 1, which says, the new 2% fee cap would exclude fees for an appraisal performed by a third-party appraiser. Doesn't mention evaluations. We can discuss whether it would be appropriate to specify evaluations are excluded.
Thank you.
Okay. We get a response in the chat?
We're good.
Okay. Okay. Any other comments? Okay. Wait, just a few more seconds.
You can remind people when we'll take written comments, so.
Yeah. So we are accepting informal written pre-comments till 5 p.m. this Thursday. You can email those to Lori Hops. Our contact information is in the meeting notice. And we're happy to get more information or any kind of elaboration you have on any comments you may have made here. Give just a few more seconds to make sure no one has any comments. Okay. Well, again, thank you for coming. This input is really valuable in developing the best interpretations possible. We appreciate you taking the time to come see us. We are accepting informal written pre-comments, and we look forward to hearing from you. Thank you.